See the Lucas Classical's case on the competence of the court, which is competence of the court, and again, citation, citation. The primary issue of the jurisdiction is simple, no legal, only much has the unwavering duty to have it one way or the other before the court, Yes. Because of AG Adamawa State and AG of the Federation. The case of Okarika, Samuel, captured the case of Bakara and others versus Nasamu and others. Citation is also captured. The court is bound to express writing the objection raised before it was to consider the merits of the case. There's no doubt. The question raised by the defendant borders in this court, as stated earlier. The attention of the defendants in their final written address, the learned counsel raised the objection of service of reaction. Let me at this stage the way and manner. Learned counsel cited a particular case. I don't cited the case as I quote, not I versus Anvich. Citation was provided. May I point out to learned counsel that the names of the parties in that case were not properly cited as contained in that particular volume of the law report is cited. Correct name of parties in that case as contained in that volume of the law report is Anoye versus Kanyip. It has been held in that counsel when citing cases in the citation. See the case of Ogudo and the state citation capture. The case of others versus governor and another citation is also captured. This is because decisions of courts, particularly that of the U.S. court, are binding on all courts by virtue of fair decisions. As such, when counsel are citing cases, they should ensure accuracy in the citations given by citing the correct names of parties, the year and the volume of the report they are citing from, in order for the court to confirm and apply same in appropriate cases and not to mislead the court. I'm aware that section 24.2 of Local Government Service Commission Law 2014 provides for 1 month reaction notice of intention to commence action. The claimant, on the other hand, argued in response to the said objection in her final objection that they had served the letter, but was copied to and duly sent, which they presumed to be a reaction notice. I've gone through the said letter. The counsel referred the court. I can say that there is nothing in the said letter that states that it is a pending legal action given the required notice as expected of it. Be that as it may, it is well established that jurisdiction is of substantive and procedural jurisdiction. See the case of Covaland, Oil and Ecobank Nigeria citation captured. Achonu versus Okuobi citation captured. Ihebi versus Zachary citation is also captured. Where the issue raises as to whether jurisdiction is vested statutorily in the court, then that is substantive jurisdiction. But whereby is merely whether it was filed properly or not in the course of the case. Such is secondary and is on the procedural jurisdiction. In the case of Heritage Bank Limited versus Bentwood citation captured, the Appeals Court held that the distinction between the two lies in the fact that while procedural jurisdiction can be waived, substantive cannot be waived. See also the case of Indaya versus Zantoro citation captured. Thus, a litigant may submit to the procedural jurisdiction of a court, for instance, where a writ has been served outside jurisdiction without leave, or where an action is brought to the court non-service of action notice by learned counsel to the defendants in the final written address as the non-service is a matter of procedural jurisdiction which may well be waived. The pertinent question to be asked now at this stage is whether the defendant can raise the issue of non-service of pre-action notice at the stage of their final written address when they have failed to make it an issue in their notice of preliminary objection and took a step further by filing their statement of defense in the proceedings to the conclusion of trial. It is now firmly settled. The objection to the issue of non-service of pre-action notice ought to be made soon after the service of the originating process on the defendant before entering defense or filing his statement of defense. See the case of Vinoye and Vinoye. Where it was held that pre-action notice should be raised preferably soon after the defendant is served with a writ of summons. In the case of registered trustees, ASP and MDA versus John citation captured, the court held that failure to serve pre-action notice where it is required is only an irregularity which renders the action incompetent but can be waived where a party fails to make it an issue either by motion or statement of defense, he has waived it. Failure to make non-service of pre-action notice the ground in the preliminary objection amounts to a waiver of same. See also the case of the case of Ames Electrical Company Limited versus FAN citation captured. In view of the above decided authority, I am of the view that it is too late for the defendant to be raising same in their final written address due to their failure to raise. This means they have waived their right to raise same. Thus, the defendants are already before the court and have joined issues with the claimant in this case. They are thus deemed to have waived their right to raise the issue of pre-action notice. It is a constitutional right of a party to approach the court to ventilate his or her grievances, and the court, by virtue of Section 6(b) of the 1999 Constitution as altered, has the constitutional power to assume jurisdiction and adjudicate on same. This, in the light of all said herein before, that I resolve issue 1 against the defendants. Before I start addressing let me have the state of learned counsel. For the defendants, in paragraph 5 of the final written address on the competence of the reply to the statement of defense filed by the claimant on the 19th of March 2021. It is learned counsel's submission that the said reply is not competent for the court as it was filed outside the record because their statement of defense was deemed filed on 22nd of February 2021. However, did not file clean copies of a joint statement of defense and accompanying motion until the 18th of March 2021. And learned counsel, K.S. Sule of counsel, undertook to serve the said process on the claimant counsel on 19th of March 2021. Learned claimant counsel then filed reply to statement of defense on the 19th of March 2021. May I humbly remind learned counsel for the defendants that the copies attached to the affidavit in support of a motion for extension of time are exhibit or proposed statement of defense before the court and are properly marked so in the said affidavit. Thus, there is need to file a separate clean copies of the said process after the grant of same by the court. Until the separate copies different from the one annexed as exhibit to the affidavit in support of the motion are filed and served on the claimant counsel, the time will not run. This is because counsel cannot reply to what he has not been properly served. This court is of the view that time will start running from the time learned counsel receives the clean copies. If learned counsel wants this court to discountenance the because the one annexed to the motion as exhibit suffices, why then did he file and serve a separate clean copy of the statement of defense? It It is view of the evidence and record respecting the defense filed as well as the reply filed on 19th March 2021 that I find and hold that the reply filed by the claimant on record is competent. In respect of issue 2, claimant case is that she was employed by the first defendant, which is a body created by law. The letter of employment of the claimant was pleaded and relied on by her. The defendants, on the other hand, neither disputed same in their statement of defense, hence it is deemed admitted. The court in the case of Amma and Amma, citation captured, held that a fact is deemed admitted if neither denied specifically nor denied by implication. Having said that, it is not in dispute that there exists an employment relationship between the defendant and the claimant. Now, in furtherance to what is being said, it is germane for the court to determine the type of employment entered into by the claimant and the defendant in this present, the determination of which will help in the judicial determination of the case before the court. The law in the world of work is settled as regards the categories of employment that exist, which are master servant, servants who hold office at the pleasure of the employer, and employment with statutory flavor. See the case of Controller General of Customs versus Gazelle, citation captured. The first defendant is a body created by law, that is Kogi State Local Government Service Commission Law, SUPRA. It is worthy of note that the fact that an employer is a creation of statute does not elevate his employment to one with statutory flavor. See the case of Audu versus Petroleum Equalization Fund Management Board, citation is captured. It is tried that before a contract of employment can be said to have statutory flavor, the contract of service is governed by statute or where the condition of service are contained in regulations derived from statutory provisions. See the case of Kwara State Judicial Service Commission and another versus Tolani, citation is captured. Contra General Customs versus Gusau, SUPRA. In essence, where the employer is a creation of statute and employment and condition of service expressly spelled out in a statute or where the power to make the regulation or condition of service is derived from the statute, the employment is one which enjoys statutory flavor. Section 9, subsections 1 and 2 of the Kogi State Local Government Service Commission Law, hereinafter referred to as the law, set up the first defendant clearly, provides thus, I quote, subject to the provisions of this law and any other enactment, appointment of persons to hold or act in offices in local government, including power to make appointment and confirm which appointment made, and to dismiss and exercise disciplinary control over persons holding or acting in such offices, particularly persons on grade levels 07 and above, shall vest in the commission, subject to such condition as it may think fit, delegate any of its members, a committee, or any person in the service of a local government to perform this function. Subsection 2, nothing in this section shall be construed as limiting the power of any local government area to appoint and discipline other officers below salary grade level 07, unquote. In the same vein, Section 10, subsections 1 and 3, 1 to 3 of the law provides, and I quote, the commission shall have power to set up general guidelines for appointment, promotion, training, transfer, discipline of staff employed in local government services. Appoint, confirm appointment of staff in the local government service on the recommendation of the chairman of the local government area, subject to availability of vacancies in such local government. In doing so, the principle of federal character shall be adhered to at the point of entry. Just a minute. Thereafter, from grade level 10 and above, the mechanism or criteria for promotion shall be based on the usual accepted principle of experience, competence, seniority, performance in the job. C, dismiss and exercise disciplinary control over persons holding those offices. D, monitor the activities of each local government to ensure that the guidelines are strictly and uniformly adhered to. E, serve as a review body for all petitions from local government in respect of appointment, promotions, and discipline of employees in the local government service. Subsection 2, it is the duty of the commission to make rules, regulation, and guidelines in respect of matters relating to A, qualification required for appointment, B, schedule of duties, official designation and condition of service, procedure and requirement for promotion, D, periodical return and information to be supplied to the commission by all local government areas, E, maintenance of discipline, F, items and condition of service, including without prejudice to generality of that expression, salaries and allowances, the grant of advances, provision of staff quarters, annual or maternity leave, equate them with those obtained in respect of employees in the state public service. G, form any agreement to be entered into between local government and its employees. H, transfer of employees between local government and the state. I, retire functions as may be assigned or delegated to it by the governor. Subsection 3, except as provided for in this law, in the exercise of its powers under this section, the Service Commission shall not be subjected to the direction and control of any other authority or persons except the governor of the state, unquote. The provisions of the law reproduced above are unambiguous and requires no aid to interpret. Section 9 gives the commission the power to appoint and discipline persons from grade level 7 and above or on any term as and condition as it deems fit. Such powers shall not be construed as limiting the power of any local government area to appoint and discipline officers below salary grade level 7. Section 10 gives the commission the power to make prescriptions on terms and conditions of service, the procedure for promotion, maintenance of discipline, including dismissal, termination of appointment, and such other matters relating to the departmental procedure duties and responsibilities of employees as the committee considers can be best provided for by regulation. I find it plain on record of court that the claimant was employed prior to the coming into force of the law captured above in 2014. While a promotion as principal executive officer, offer of promotion and notification of appointment, the court take cognizance of the provisions of sections 37 and 38 of the law, which provides those, and I quote, Section 37, subject to the provisions of this law, sections 45, 46, 48, of Kogi State Local Government Law 2000, Section 38, I quote, shall be deemed to have been done under corresponding provisions of this law. 2, any officer appointed before the commencement of this law by the commission pursuant to regulations and guidelines made hereto shall be deemed to be duly appointed into that office, unquote. It is thus clear from the above provisions that as a nexus and is deemed to have been made under the law which set up the first defendant. It is not out of place for the court to make a finding that the claimant's employment is one laced with statutory flavor by the combined effect of sections 37 and 38 of the law. However, the fact that an employment is loaded with statutory flavor does not guarantee the success of an action on unlawful termination or dismissal of employment. It is well settled that in an action for unlawful dismissal of employment, the claimant is required by law to plea and tender in support of his case or her case, and in some cases a regulation or an alleged citation captured. Case of Nitel and Idigbe, citation is also captured. As such, the claimant has the onus to first place, the second to prove the way I'm there. See the case of Allah on top of Rahim. Citation capture Stikano. Citation is also provided. Unlawful termination or dismissal of employment arises where in carrying out decision to terminate the employment, the employer fails or neglects or refuses to adhere to the principle. You do FECO versus Pfizer Products Limited citation capture. In essence, notwithstanding the common law right of employment lays with statutory flavor, must observe and adhere strictly to the terms and conditions of employment as protected by statute. In the instant case, the claimant pleaded by her statement of facts that she would contend at trial that her dismissal by the defendant was grossly unlawful, improper, and wrongful. The claimant did not do a good job in the numbering of the paragraphs of the claimant's statement of facts. This court finds at pages 7, 8, and now the record of court that the paragraphs were wrongly numbered, especially at pages 8 and 9 of the record, as they did not follow sequentially from the previous paragraphs. Thus, this court will in its inherent power renumber the affected paragraphs at pages 8 and 9 of the record. The affected paragraphs wrongly numbered are paragraph 17, 18, another 18 and 19 are pages 8 and 9 of the court record are renumbered thus. Paragraphs 19, 20, 21, and 22 to follow the sequence. Accordingly, it is the claimant's pleading, read paragraph 19 of her statement of fact, that her dismissal is unlawful. As reasoned supra, a claimant in an action for unlawful termination or dismissal has the onus to first place before the court the terms and condition of her employment and plead in what manner the condition was breached. Claimant merely pleaded by paragraph 2 of the statement of facts that the first defendant is the service body responsible for employment and service condition of local government staff in Kogi State. The said power is equally recognized by Section 10 of the law. The claimant throughout trial did not plea with the defendant, did not plea or tender the particular condition of service regulation or regulation which governed her employment with the defendant. It is worthy of note that the claimant tendered a letter of appointment marked as Exhibit Q1, as rightly observed by learned counsel for the defendant, which she accepted in item 7, is that she will comply with all the conditions of service stipulated in local government staff regulations and other local government regulations and instructions for the time being in force. Thus, it is clear that there is a particular condition of service as stipulated in local government staff regulation, which governs the employment relationship. In the case of Okomo Palm Company Limited versus Inshe citation captured, the Apex Court held inter alia that it is important for the employee to plead and prove the condition of service regulating the employment because it is what he or she must rely on in the course of showing in what way and manner it has been breached. The failure of the claimant to place before this court the particular conditions of service that governs her employment is fatal to her case. This court takes note of the submission of learned counsel for the defendants in paragraph 5.8 of his final written address that the applicable staff regulations is the Kogi State Local Government Service Staff Regulations 2010, whose continuous application is sanctioned by the provisions of Section 38(2) of the law. The learned counsel also made copious references to portions of the said regulation. It is worthy of note that neither the claimant nor the defendant placed before this court the said regulation of 2010, which governed the employment relationship. It is now well settled that address of counsel, no matter how beautifully written or captured and tempting, cannot take the place of evidence in the court. See the case of Sharing Cross ES Limited versus Umaru Adamu Enterprise Limited, citation captured. The case of Andrew and INEC, citation captured. The case of Urubo and the state, citation is also captured. Thus, the submission of learned defense counsel can be of no help since the particular condition of service is not before this court, I so find and hold. The claimant is equally required to plead and prove in what manner the condition of service was breached by the defendants, as I've stated earlier. I've read through the whole 22 paragraphs pleadings of the claimant as contained in the statement of facts, and I cannot find anywhere the claimant pleaded in what manner the terms and condition of employment was breached. I've taken note of the testimony of the claimant in paragraph 19 of her statement on oath, whereby she stated that she was never queried or given any form of hearing before her purported dismissal was effected by the defendants. I agree with submission of counsel to the defendants in his final written address that such evidence goes to no issue. This is because parties and also the court are bound by their pleadings. As such, evidence led on facts not pleaded go to no issue. See the case of Adeke and additional citation is captured. Thus, the evidence of the claimant that she was not queried or given any hearing, which is not in sync with her pleading, is thus discountenanced by this court. Now to the issue of the reason given by the employer for the dismissal of the claimant. The claimant viewed, just a minute. The claimant viewed her pleadings, which fact was equally admitted by the defendants, averred that she was dismissed from the service of the first defendant on an allegation of forgery of certificate as seen on Exhibit Q, that is her letter of dismissal. It is equally clear from the pleadings of the defendants that the claimant was alleged to have forged her certificates. I perused the exhibit relied on by the defendants, and I find a letter dated 23rd of July 2018, written by the chairman of the Local Government Service Commission, marked as Exhibit K1, wherein it was stated thus, and I quote, "Further to our recent letters to you on the above, I am directed to ask that names of the officers contained in the attached list for various local government area staff who have been confirmed to have presented fake/forged certificates during the recently concluded staff screening and verification exercise be expunged from the payroll of the service without further delay. 2, the LGS staff list contain 70 names. And 3, you are hereby directed to commence disciplinary procedure leading to dismissal of the culprits in line with Public Service Rule number 030402. And lastly, thank you, unquote. Attached to the above letter is one document and there's 2, titled, quote and unquote, civil servant with confirmed fake or forged certificate for legal and disciplinary actions. With the name of the claimant as number 2, reference to Public Service Rule, PSR number 030402, in the said Exhibit K1, under which disciplinary action is to be conducted, implies that the allegation against the claimant is seen as serious misconduct as contained in Rule 030402 of the PSR. It has become obvious at this stage that the regulation under which the claimant was disciplined, leading to a eventual dismissal, is the PSR. I so find and hold. It is well settled that in statutory employment, just as in private employment, Where an employer alleges the employee to have committed a misconduct, the employer must give the employee an opportunity to defend himself for the said misconduct. See the case of ZDE versus Rivers State Civil Service Commission. In the instant case where the claimant's employment is one with statutory flavor, demands more than merely giving a query and answer to same. Exhibit K1, which was relied on by the defendants, clearly state that discipline of the claimant should be done in line with Rule 030402 of the Public Service Rules, and which borders on serious misconduct, which is defined as serious case that is inimical to the image of the service, which may lead to dismissal. The procedure for dismissal under the PSR, as stated in Rule 030307 of the PSR, are supposed to be followed. There's no gainsaying the fact that the procedure listed in the PSR is to ensure that fair hearing is given to an employee before dismissal. The pertinent question that should be asked at this stage is, was the claimant hearing given an opportunity to defend herself as is required under the PSR, which the first defendant was supposed to carry out before her dismissal? There was, however, nowhere in the claimant's pleadings, both statement of fact and the reply to the statement of defense, where she complained that she was not given an opportunity to be heard, except the one contained in paragraph 19 of her statement on oath, which this court has reason supra has jettisoned for not being in sync with her pleading. This court takes note of the contention of a defendant's bid, paragraph 3G of the joint statement of defense, that the claimant was queried and she appeared before the committee and was heard in defense of the allegation leveled against her before she was dismissed. The claimant filed a reply to the joint statement of defense on the 19th of March 2021. However, the claimant did not specifically join issues with the defendants on the facts pleaded in paragraph 3G of the joint statement of defense. It's long settled that where a plaintiff or claimant fails to deny a material averment in the statement of defense, is deemed to have admitted same because he has failed to join issues on those facts. See the case of Kezia and Iwaha, citation captured. The case of Achimugu versus Minister FCT, citation is also provided. As such, the said facts having been admitted need no further proof. Thus, the claimant herein having failed to join issues with the defendants on the fact that she was queried and given an opportunity to defend herself before a committee is deemed to have admitted same, and which fact requires no further proof. The effect of this is that the claimant was queried and also appeared before a disciplinary committee before her dismissal by the defendants. I so find and hold. The court also takes note of the contention of the claimant in their pleadings in Exhibit Q was done in error and was corrected by her school. It is the claimant's case, bid paragraphs 11 and 12 of the statement of facts, that the school wrote two separate letters to the defendants in respect of this error, and in spite of this letter employment. She relied on exhibits Q5 and Q9, which are letters from her school, Niger State Polytechnic, Zungeru, addressed to the first defendant and governor of the state through the chairman of the first defendant, dated 6th June 2018 and 15th August 2018, respectively. Although there is no stamp on exhibit Q5 to show that it was received, there is, however, a stamp of the first defendant on exhibit Q9 to show that it was actually received. More so, the defendant did not deny receipt of the letter in their statement of defense, neither was the existence or authenticity of the said documents denied or challenged in their statement of defense. Thus, it is not in doubt that the defendant received exhibits Q5 and Q9, which were both made before the dismissal of the claimant from the employment of the first defendant. In other words, they knew before dismissing the claimant that her certificate is authentic, as against their position that she presented a fake or forged certificate, the ground upon which they dismissed her for the first defendant from the first defendant's service. It is the contention of 5.6 of his final written address filed on behalf of the defendant that the claimant cannot tender the document because she is not the maker of the said documents, and as such, the authenticity of the documents is in question. It is established in law of evidence that the proper person to tender a document is the maker of such documents. This is because the person who is not the maker of the document cannot answer questions on it. As such, documents tendered through persons who are not makers of the documents should not be attached probative value. See the case of Lambert versus Nigerian Navy, citation capture, the case of Inyama and Akpabio, citation capture, the case of Chukwu and Federal Republic of Nigeria, citation captured. However, it should be noted that it is not in all instances that it is necessary to tender a document through its maker. It is necessary to tender a document through its maker where the authenticity of the document is challenged. The defendants throughout their statement of defense did not deny receiving a copy of the said letter from the school as stated earlier. They equally did not in their statement of defense contend claimants' averments that our school later wrote a letter to the defendant or the authenticity or existence of the said letter relied on by the claimant. They equally did not in their statement of contend claimants' averment, yes, that her school later wrote a letter to the defendants or challenge the authenticity or existence of the said letter relied on by the claimant. In the case of Iwoye and FAA citation captured, the Supreme Court per Sanusi GSC at pages 209 to 2010, paragraphs G to B held that it is unnecessary to tender a document through the maker where the authenticity or existence is not challenged. The court went further to hold that even though the said exhibits in the case were in the form of secondary evidence as originals of the letters were not the ones tendered and admitted in evidence, that could not be a reason for the person who fails to tender the original copies to fail, especially where the content of the original was given during oral testimonies, as in this case. See also the case of Abubakar and Waziri, citation captured. Thus, in view of the fact that the defendant did not deny the existence of exhibit Q5 and Q9, neither did they challenge the authenticity of the said documents in their statement of defense, and the fact that the claimant already gave evidence of the contents of the said exhibit in paragraph 14 and 15 of the statement on oath. This court finds that it is unnecessary for the claimant to call the maker of exhibits Q5 and Q9 to tender them. I so find and hold. Now, it is of note that both exhibit Q5 and Q9 were received by the defendants prior to the making of exhibit Q, as stated earlier in this judgment, which is the letter of dismissal made based on reliance on exhibit K, the first letter sent by the claimant school. This court is of the view that the defendants, upon receiving exhibit Q5 and Q9, should have retracted its earlier decision and then acted on the said exhibit, which is an essential determinant of the allegation against the claimant. There's nothing on exhibit Q to show that the defendant actually considered the said subsequent letters exhibit Q5 and Q9 before dismissing the claimant. For this reason, this court is of a respectful view that the claimant was not given fair hearing, notwithstanding the fact that she was queried and appeared before a committee. In view of the subsequent revelations, the defendant should not have proceeded to dismiss the claimant on the strength of exhibit K, which exhibit Q5 and Q9 have boldly stated to be an error, with the attached transcripts of the claimant and all calls he made in the cause in proof of the fact that the claimant did, in fact, attend the school and lawfully obtain the certificate in question. This court is therefore of the view that the claimant was not given fair hearing as required by law, or failure of the defendants to consider exhibit Q5 and Q9 being the trust or the basis or the foundation upon which she was dismissed. The implication of their action is that they dismissed the claimant without any justifiable reason. I therefore find from all the facts and evidence on record that the dismissal of the claimant was unlawful. I so find and hold. Further to the above, it is also well settled in labor jurisprudence that an employer is not bound to give reason for terminating or dismissing the employment of an employee. However, there is a rider, and that is that where an employer gives a reason for dismissal of an employee, such reason must be justified. See the case of SPDC Nigeria Limited and Olariwaju, citation captured. The reason given for the dismissal of the claimant is the allegation of a fake or forged certificate. It is therefore doubtful if the defendants have justified the dismissal of the claimant in view of the existence of Exhibit Q5 and Q9, which were received by the defendant and which is an essential part of this case, as I've reasoned before they dismiss the claimant. It is in view of this that I find that the claimant's dismissal is unlawful and unjustified by the defendants. Now to the relief sought. The claimant in her, just a minute. Now to the relief sought. The claimant in her relief 1 sought for payment of special damages in the sum of 12,687,300 naira for her unlawful and unwarranted dismissal. It is well settled that a claimant who claims special damages must specifically plead the sum claimed with distinct particularity stating the sum claim item by item with corresponding monetary value of the item claim, which must equally be supported by credible evidence. See the case of UBN versus Nwakwo, citation provided, the case of MBC PLC and Bani, citation captured, the case of MWT Nigeria Limited versus PTF, citation equally captured. Claimant herein who will want the court to grant special damages in this case failed to do all that is required of her by specifically pleading and proving her entitlement to the said sum claim. She's claiming the sum of 12,687,300 as special damages. What she did was to list certain amount as salary owed her since 2013 to 2018, and then modeled it up with salaries as she's expected to earn from 2018 for 10 years next. That is the total sum she's claiming. There's no single evidence of record to substantiate this claim. She did not tender her payslip or account statement to show how much her salary is per month and when last she was paid salary. That is fatal to her case. Thus, this court cannot grant an unsubstantiated claim. Relief 1 is thus discountenanced. The claimant in her relief 2 is asking for payment of monthly pension calculated at the rate of basic salary of 35,000 naira to the claimant. Notice of the notorious fact that pension is usually paid to retired officers. The claimant has not pleaded that she was already eligible to receive pension or that she has attained the compulsory retirement age. In fact, claimant by paragraph 17 of her statement of fact averred that she still has 10 years more in service before her retirement, and which fact she reiterated in her written statement on oath. There's nothing in the facts pleaded by the claimant to support the grant of this relief, consequent upon which relief 2 is refused. Now it is clear from the above finding of this court that the claimant's dismissal by the first defendant is unlawful. Instructively, the law is tried that with statutory flavor has been unlawfully dismissed, as in this case. The implication in law is that the employee never left the service of the first defendant. Parties are therefore back to the status quo ante bellum. And University of Lagos, citation captured, and the case of Shitobe versus Federal Public Service Commission, citation is equally provided. Substantial justice, therefore, demands that the court makes a consequential order for the claimant to be placed back to her former position in the first defendant's employment and pay all her salaries as if she never left her employment up to date. Orders to cost. Judgment is accordingly entered.
Please.
Copy of the judgment will be sent to Lokoja to the parties.
Scott, please.
Lokoja.
Yes, my lord.
Yes, just give me a minute. We shall proceed.
His report and possible proceeding. What is wrong when people are coming with points? Because
Taking that and just from saying
to say to do what? No. Huh? But me?
Lokoja, I'm back.
Yes.
So go ahead, court registrar, and call the case.
Yes, number 2, NICNA 12/2020, Onu Moses. 2, Agala Sunday. 3, Honorable Nathaniel Idoko. And 1, Kogi State Government. 2, Attorney General Commissioner for Justice. 3, Olamaboro Local Government Council. Okpo. First claimant is in court, my lord. Others absent.
Just a minute.
Defendants are absent.
First claimant present.
Yes,
my
my
lord.
lord.
Okay, first and second claimant are in court, my lord. Third
Okay.
absent.
Defendants.
Absent, my lord.
Appearances.
May it please me, Lord. I am honored Jairo.
Onoja AO.
Yes, my Lord. Appearing with D.A. Oboni. But the
With
claimant, P.A. Oboni, my Lord.
With you is, please use your audio, use it. I can't hear you.
I think I'm appearing with. Hello?
Who is with you?
P.A. Oboni, P.A. Oboni. For the claimant.
Very well. Any other appearance?
Yes.
for the defendants, my lord.
Uh-huh.
My lord, appearing for all the defendants. M.A. Okpanashi,
Go ahead.
Assistant Director, Public Prosecution.
What's the initial?
M.A. M.A.
Okay, M.A.
Yes, Okpanashi.
Very well.
Assistant Director, my Lord, Public Prosecutions, Kogi State Minister of Justice. I appear, my Lord, for all the defendants.
Very well. How far have you gone with settlement?
Yes, my Lord. As a matter of fact, the claimants and particular and all the defendants, we have reached a term of settlement, sir. We've drawn a term of settlement.
Very well.
My Lord, hereafter, the third defendant who is directly affected by this suit, my Lord, obtained a copy.
The third defendant.
Yes, my Lord, they are the one directly affected by this suit, obtained a copy of the terms of settlement. And submitted same, my Lord. And submitted same, my Lord, to the Ministry of Local Government and Shifting Affairs, Lokoja, Kogi State. They submitted the said terms of agreement to the Kogi State Ministry of Local Government and Shifting Affairs.
Very well.
My Lord, to obtain consent, my Lord, so as to be able to pay the admitted sum. My Lord, till this morning, my Lord, to this very moment, the said consent have not been obtained. Till this moment, the consent has not been obtained from their mother ministry, my Lord. On our part, sir, we have consistently tried to prevail on them.
You are consistently doing what?
We have consistently prevailed on the ministry to give their consent to the terms of settlement.
You are consistently
prevailed, sir.
Yes, I've gotten that.
Yes, sir. So that the
Very
third
well.
defendant, my Lord.
So what do you want the court to do now?
My Lord, we are still in the process of asking them to give their consent. Without that, my Lord, the third defendant would be unable to settle their admitted sum because funds
the
are
court
able to
give an adjournment.
My Lord, sir, we still urge the court to grant us another date, sir. Urge the court to grant us a further date to prevail on them and to make them know the repercussion of this delay, sir. We have not been indolent on our part, sir. It is only the consent that we are waiting for, sir. The third defendant cannot pay these debts, sir, unless they were given that consent from their mother ministry, sir. That is the constraint we have faced, my Lord.
Mr. Onoja. Mr. Onoja.
Yes, my Lord. In reaction to what they have said,
yes,
court cannot wait for the mother ministry, as he is saying. The mother ministry, court does not wait for anybody, does not wait for litigants. We are here for serious business. Yes, my Lord. Based on that, I will be relying on the order 38, Rule 4. Order 38, Rule 4, Rule 16, Sub 2, Sub 3, C and E. Hello, my Lord.
Mr.
Yes, my Lord.
I had to mute myself and so I didn't hear you. You said
We'll be relying on that on order 38, Rule 4,
order 38 Rule 4.
yes, my Lord, and Rule 16,
Mm-hmm.
Sub Rule 2 and 3, Sub Rule 2, 3C and E
Uh-huh.
of the rules of this honorable court. To
Mm-hmm.
make an application under order 34,
Uh-huh.
under order 34, rule 4 of the rules of this honorable court,
Mm-hmm.
to ask your lordship to enter judgment in terms of the admitted facts, in terms of the admitted sum, which you have already informed this court at the last adjourned date.
The admitted sum, is it in their statement of defense? Is it in the defendant's statement of defense?
No, my Lord.
It's not in their pleadings.
Yes, my Lord. But by the rules of this honorable court, especially order 34, rule 4,
What does it say?
it says that at any time, in the circumstances that we are, your lordship we can make an application for your lordship to enter judgment based on the admission by the parties. These rules were given judicial backing by decision of Superior Court.
It has to be by the parties pleading, or otherwise in writing.
Otherwise in writing, otherwise
Yes,
it has
the
been
third
explained,
party
otherwise,
admits the truth of the whole or any part of a case.
yes, otherwise have been interpreted by both Supreme Court and Court of Appeal to include oral admission based on Section 20 of the Evidence Act. So we are in court with such authority to assist courts to go through the Superior Court decision and did the needful.
Where did they make the oral admission? Where and when?
Before your lordship, as at the last time, counsel have admitted that
What
this is our
date?
admission.
What date?
The last time we were in court, that was before Christmas. That was in October.
That was when?
October, the last sitting of this court in October, where CD
What did he
representing,
say?
he said that is the position, and they have agreed to pay 35 million. They have agreed to pay 35 million.
No, there is nothing of such on record. CD,
Lord,
just a
October
minute,
18th. Okay.
just a minute. CD said parties have met terms of settlement written. We could not file because the third defendants have not obtained the approval. We plead for an adjournment.
Yes, Lord. I told you, I informed this court that this is the terms of the settlement, which they considered 35 million. And they considered the same application is what.
No, there isn't any such in even what you said. It said amount, and this court has the power to regulate its own practice and procedure.
Yes,
so I would prefer that is in writing. I cannot just based on what you are terming an oral admission, which is not even seen on record of this court, to now go ahead and enter judgment in an unknown sum. Because to this court, as it were, that sum is not known. There's no record of this court that any specific sum is admitted by the defendant. So what I would do now is to give you further date to enable the defendant, and this will be the last date. That's the only thing I can do.
Justice demand that since Emro Panachi is in
Except if
court,
you have filed the terms. If you have filed the terms, you can ask the court to intercede.
And that is why Order 38, Rule 16 says they are delaying this proceeding. They don't want us to proceed. And you have been,
and then if you want the court to proceed to trial, then the court can proceed to trial. Or not to enter judgment in an unknown sum.
Admitted to pay a certain sum, he can equally tell the court, this is the sum admitted by the meetings.
And then tell him to admit. Tell him to tell the court.
Tell the court, the terms of settlement is here, and what was admitted is on the terms of which we tell the court, we proceed.
The terms are not before the court. Except if you had filed it. But since you haven't filed it, there's no court that can grant such. So I won't grant that application. If you like, go and file your terms. If you have signed the terms, you can file it. When you file it, parties may come and adopt it and urge the court to enter it.
My Lord, sir. What Okarachi told the court is that we have reached the terms of settlement. They took it away since March. Since March till this day, they have been returning, they refuse. And each time we call them, we talk to them, they say, we still maintain that position. Maintain the position, bring it forward. They are not bringing it forward. Do we have to stand in a stagnant position because of their indolence? No.
You have an option. And that option is for you to go ahead and prove your case.
So then we can proceed to trial today. We are ready. If they are not ready to make us proceed, we can proceed to trial. We cannot be waiting for them all this time. Even if you give them another date and they come to court, we will still go by the same story. So we apply for life and so that.
What date to trial? If settlement has broken down, what date for trial?
16th March. 16th March. 1/6.
Is it convenient?
Yes,
Lord, sir. Lord, sir. So, we have agreed to take an opportunity of Order 38 to 33. That is what we have just agreed. Instead of wasting time, let
then
us.
You tell the court, Mr. Panachi, are you agreeing to that? Did you tender the said, look at the paragraph 4 of your pleading, of your release.
Hello?
Did you tender, look at paragraph 4 of the release.
I'm sorry.
Did you tender the schedule of the outstanding salaries and allowances of 2013 to 2016 before the court?
Yes. I'm sorry.
Basically, what I'm asking you is whether or not you have any documents on record particularizing the said salaries owed by the claimant.
Yes, my Lord, very much. Part of the exhibit concluded, my Lord.
Okay. Oh.
Yes. And by their pleading, they admitted to saying,
You admitted is the particular sum.
yes.
And that's why I asked you, if they have admitted the particular sum, then you can ask that the court should enter judgment in the specific sum admitted by the defendant. That's the particular, I mean, that's the other 34 you referred to.
Yes,
That's what
Lord.
it says.
No.
But if there is nowhere by which the defendant admitted specifically certain sums owed the claimant, then you cannot.
No, there is.
Which paragraph of the defense?
I'm confirming, Lord.
Mr. Panachi,
Yes.
is it true that you admitted that specified sum?
Paragraph 8, paragraph 8.
Sum of 27 million. Paragraph what?
Paragraph 9, admitted in paragraph 9.
Of the statement of defense.
Defense, yes. Paragraph 9, paragraph 11. Then what is admitted here, paragraph 6 to 9 is in the tabulation that we concluded to court. Only that we have to put them, we have to round them up to come with a particular figure. The table has front-loaded. Here's the chart.
Mr. Onoja,
Yes, Lord.
asked you a specific question. Is there a portion of the defense that admitted that specified sum of 12 point something million that you are claiming as salaries owed the claimant?
They admitted the functions that they owe for specific months, which is part of our fee. They admitted percentage of salary owed for specific months.
But they didn't admit specifically the sum of 12 point something million.
Well, our claim is more than 12 point something million, my Lord, sir. It's over 29 million put together. And they are all in charts. And from what they admitted, if you put them together, it will arrive at the sum.
Well, since there is nothing in their pleadings admitting specifically that said 29 million or more, then the court cannot enter judgment. But I'm even looking for.
If you look at paragraph 9, like I said,
joint statement of defense.
Statement of vote is attached to a motion for extension of time. It's annexed to a motion for extension of time.
The statement of defense.
There is a motion for extension of time filed on the 27th, dated the 27th day of January 2021, and filed on 25th. How can you date it 27 and file on 25th?
Mr. Okpanachi,
He's talking to you back.
Yes, my Lord.
is Mr. Okpanachi there?
Yes, my Lord.
You have blocked your video.
No, I'm with you, my Lord. Sorry, my Lord.
Is there any part of your pleadings that you admitted specifically the amount claimed by the claimant?
My Lord, our admission is not in as per the total sum being claimed, my Lord, but some part of the claim, sir. Particular paragraph 9. Paragraph 9, my Lord.
Statement of defense. Sorry, we can't find the statement of defense.
Wow. My Lord, it came with a motion for extension of time, my Lord. Dated
Yeah,
27th January.
I've asked that the court start to look for it. Said she couldn't find it because I couldn't find it. That's why I asked that he should look for it.
Scott, please.
He said they are tied to the motion for extension of time.
Yes, my Lord. Yes.
So you're talking, you said that there's nowhere in your pleadings where you specifically admitted a certain sum.
Paragraph 9 is the only paragraph within which we admitted owing certain percentage of the salary of the defendants. Paragraph 9.
Okay.
Yes.
But it wasn't did you specify an amount?
We did not specify amount, my Lord, but we specified the period within which that amount of salary accrues. 20% in 2013 and then 2014.
And not in 2015 and 2016.
We did not admit that of 2015 and 16, sir. Not at all, sir.
Okay, okay. Let me ask Mr. Onoja. You said you have a schedule attached to your pleading.
Yes, yes, ma'am.
Stating all the
outstanding salaries, entitlements,
including the monthly salary of the claimant. You have a document showing the monthly salary of the claimant before
they
the
are
court.
they are the one that prepared what they are owing. The defendant prepared the one that prepared the document. And
I can't hear you.
The defendants are the one that prepared that document which you exhibited before court, and the document tallies with paragraph 9 of their statement of defense.
Very well. So go ahead and tell me, you said you have agreed to the argument on record procedure.
On record, yes, my Lord. We have agreed to take advantage of order 38 through 33.
Learned counsel, Mr. Okwanachi, you're supposed to have filed a clean copy.
My Lord.
Were you not in court when I delivered the judgment now?
I was.
Attaching a proposed document to an application for extension of time.
Very well, my Lord. I was in court, sir.
You ought to have filed a clean copy of your joint statement of defense.
I'm well guided, my Lord.
So you do that within 24 hours.
As court pleases, my Lord.
It's the same process, but it has to be properly placed before the court.
As court pleases, my Lord. I'm grateful, my Lord.
And claimant counsel Noja, if you intend to file a reply on point of law, a reply to the joint statement of defense, or you have already done so.
Reply to statement of defense.
If you are at liberty to do so, I'm not forcing you to do that.
As court pleases, I will do that, my Lord. I will do that.
If you feel that there is a need for you to file a reply to it, file immediately after tomorrow when you are served with a clean copy.
as copies. Thereafter, I'll require 2 weeks to file my
Mr. Kwanachi, do you consent to the argument on record procedure?
I do, my lord. I do.
It is in the light of the agreement of both counsel to adopt the argument on record procedure that this case is to be taken pursuant to Order 38 Rule 33 of the Rules of this Court 2017. Parties are therefore to file their final written addresses. The claimant will file first. That's the procedure under the argument on record proceeding. Then the defendant will file. So, Mr. Onoja, you said you will file 2 weeks.
2 weeks. 2 weeks from tomorrow.
Very well.
Thank you, my lord.
So add that to 21 days.
2 weeks.
21 days for the defense to file.
You
And then
file
if you intend to file a reply on point of
2 weeks,
law,
my
7
lord.
days.
Upon service. 2 weeks, my lord.
2 weeks, that is
How many days?
32 days. 32 days.
How many days?
32 days from tomorrow.
14 plus 21.
No, he said he has agreed to take 2 weeks.
He also has agreed to 2 weeks. 14 plus 14, 28. And if peradventure you want to file a reply on point of law, 7 days. So that's about how many days? 35 days. 35 days from today is when? Court registrar calculated. Lokoja calculated. 35 days from tomorrow. That will end when?
4th March, my lord.
4th March.
4th of
Parties are to file their final written addresses and adopt same by writing a simple letter pursuant to the 10 of the Practice Direction 2020 on or before the 4th of March 2021. Judgment date is to be communicated to parties. So Mr. Panachi, file clean copy of your defense. By tomorrow, serve an advance copy on Mr. Onoja, who upon receipt is at liberty to file a reply. And then you go ahead and file your final addresses. Call the next case.
Case number 3, NICN LKJ 21-2018 between 1, Ismaila Jumai Zuretu, 2, Adeyemi Peter Kende, 3, Aliu Ulu Yusuf, 4, Amos Matthew Bodi, 5, Jiga Moses, 6, Siaka Austin, Ojogbe Fidel.
Who is in court? Who is in court?
First,
who are the parties in court?
my lord, the first claimant, third claimant, fifth and sixth claimants are in court.
Others absent?
Others absent.
Defendant?
Yes, my lord. Absent, my lord.
Appearances?
May it please, my lord. My name is Austin Oboni. Come this appear for all the claimants, sir.
Any other appearance? Sorry, what's the name? I can't hear you. Use your audio, please. Who? Go ahead and announce your appearance.
Lord O.W. Obaido. My Lord, appearing with me is ICU.
I what?
IC.
Group.
Yes, my Lord.
Oh,
Appearances for all the defendants.
very well.
My Lord, sorry, my Lord, holding the brief of Zedi Abbas. All the defendants.
Very well. The matter is for adoption. I wasn't expecting to see this case file on the cost list today.
My Lord, yeah, we've already written letters of adoption. So the order is still listed on the case file, on the cost list rather, my Lord. Which will be guided.
You have already filed your final written address.
Yes, my Lord. And we also filed our letter of adoption.
Yes, Mr. Oboni, why are we here?
Lord, probably to still adopt, sir. No, sir, I only saw the matter listed, sir.
I can't hear you. Use your audio properly.
No, sir. We saw the matter listed, sir, and so we probably thought we.
Have you filed your final written address?
Yes, my lord.
Then go ahead and adopt it since you are in court.
I'm grateful, sir.
When
My lord,
was
sir.
it filed? You have already written letters adopting it.
Yes, my lord, sir.
Then they are deemed adopted.
As the court pleases, sir.
They are deemed adopted today.
As the court pleases,
The
sir.
court pleases.
Call the next case. Judgment date will be communicated to parties. Who filed last? Mr. Obaido?
Yes, my lord. My lord, we filed last.
What date? When did you adopt it?
We adopted on the 14th,
Eh?
15th of December, 2021.
15th of December.
Yes, my lord.
Let me have the diary. Okay, you adopted on 15 December, so January, February, March. Just a minute, court registrar. Which one is this local there? Which suit is that? 15th of March. I hope it's not the same.
It's not Lokoja, it's Abuja.
So why did you put local?
I thought I joined to this date. It's Lokoja date, but my lord I joined that date.
Are you sure it wasn't 14th of March?
No, it was.
It was 14th. Sorry, Leonard Council. Okay, you have to see me later and clarify that. Are you sure there's no judgment here?
No judgment here. No judgment here.
On the 10th of March for judgment.
As the court pleases.
All the next case. Court registrar, Lokoja, call the next case.
NICN LKJ 16, 2019, between Moses Ibrahim and 1. Dangote Cement PLC, 2. Dangote Project Limited, 3. Lawa Muhammad Transport Obaja. Claimant is in court, my lord. Defendant.
Defendants absent.
Absent.
Appearances. Appearances, unmute yourself.
The malleable of the plea
Who is for the claimant?
May my noble Lord be pleased. I am M.O. Idigbe for the claimant.
I can't see you. I can't see you. Unmute yourself. Can I have the counsel to the claimant?
May you please, my Lord?
Uh-huh.
I am M.O. Idigbe for the
I can't
claimant.
see your face. Idigbe, I can't see your face. Who is the counsel to the defendant? Who is the counsel for the defendant?
My Lord, I'm here for the defendant.
Yeah, Musa.
Yes, my Lord.
Very well. Matter is for hearing. Ogedengbe Esquire, are you ready?
Yes, I'm here for the claimant, my Lord.
I can't see your face.
Yes, my Lord. This is for hearing this morning.
Check your audio. Do you have your witness in court? Let me know when you are ready. Do you have your witness in court?
Yes, the claimant is in court. He will testify.
I need to see your face. Invite the claimant and court registrar administer the oath. Court registrar administer the oath on the claimant. Have you both considered the argument on record procedure, Mr. Musa, Mr. Idigbe, so that we'll save the time of the court? Mr. Musa, Mr. Idigbe, have you considered the argument on record procedure?
Yes, we will take that, my Lord.
We will adopt it. Who is talking to the court?
This is M.O. Idigbe for the claimant. We will take that, my Lord.
Mr. Musa, do you agree to that?
Yes, my Lord.
Yes.
Okay, based on the document that we have before the court. It's not connected, the go.
Are all the documents legible?
Very legible, my lord. The documents are legible. Documents of the
Okay.
claimant are legible.
Do you have any document evincing the claimant salary?
Yes, the defendant attached one of the schedule of the claimant's salary.
Okay.
Yes, they are next one of the schedule in their defense.
Well, you didn't announce anything to show how much your client is entitled to.
No, my lord.
It is in the light of the consent of parties that this case is to be argued on record pursuant to the 38 Rule 33 of the rules of this court. So what date? 49 days for adoption of final addresses. The claimant will first of all file, and then the defendants will file.
File.
What did you say? Court registrar, calculate 49 days.
Yes, my lord.
49 days from today is when? Huh?
16th March, my lord.
16th March. Mr.
Yes, my lord.
Idigbe, is that correct? Mr. Musa, is it correct? Hmm? Parties are therefore to file their final addresses on or before the 16th of March, 2022 by writing a letter adopting same, pursuant to the 10 of the practice direction. Judgment date is to be communicated to parties.
As a
Or the next case.
Yes,
I hope you are clear. The claimant will file his final written address first, and then the defendant will file. Or the next case.
Case number 5, NIC Unisa Onudanjuma, and 175 others. Verse 1, Reprom Nigeria Limited. 2, Mr. Ata Achimogu. 3, Ajakuta Steel Company Limited. 4, Ministry of Mines and Steel Development. 5, Attorney General of the Federation. 6, Federal Government of Nigeria. My Lord, claimant number 49, 64, 67, 101, 106, 110, 113,
118.
113,
Okay.
113, 115, 120, 127, 131, 133, and 163 are in court. Others absent.
How about the defendants?
They are absent, my lord.
Appearances. Appearances. I can't hear counsel. I can't hear you.
May it please me, Lord. Hello, may it please me, Lord.
Yes.
Honor Yayo, appearing with P. Oboni for all the claimants.
Any other appearance?
May it please my lord. May it please my lord.
Yes.
My name is A.B. Mustafa. Hello, my lord.
Just a minute.
Okay. My lord, my name is A.B. Mustafa. I announce my appearance for the third and fourth respondent. My lord, I equally hold the brief of Mr. Olatunji A. Koka.
Holding the brief of
Mr. Olatunji O.
Olatunji.
Koka. Koka is spelled C-O-K-E-R.
Very well.
For the fifth and sixth respondent. My lord, the matter was slated for preliminary objection filed by both the third and fourth, as well as fifth and sixth respondents.
Very well.
My lord, we are ready.
Mr. Onaja, are you ready?
My lord, sir. Before then, they have several applications for extension of time.
Okay, has that been moved?
We didn't wish to file their processes. I don't think they have been moved. The first and second respondent have an application for extension of time to file counter affidavit. The third and fourth respondent have an application for extension of time. We didn't wish to file processes. Similarly, the fifth and sixth also they have an application for extension of time. We didn't wish to file process.
Mr. Onoja.
Yes, ma'am.
One Mr. Olabinto represented the fifth and sixth defendants on the 18th of March 2021. and he regularized their processes. So that means the 5th and 6th defendant had already regularized
Move
the
their own
processes they had before.
and copies.
I'm not sure of that of
Then the first and second, third and fourth.
second and third. So, Mr. Mustafa.
Yes, my lord. My lord, the application for extension of time is a harmless motion. We can move it in terms subject to my lord's convenience if the claimant counsel is not opposing to them.
Mr. Onoja, any objection?
No, no objection.
When did you file it?
My lord, the motion was dated and filed on the 4th December 2020. 4 December 2020.
Order is as prayed.
As a court, please, we are most grateful, my lord. My lord, hello, my lord.
Yes.
I have a little observation, my lord. This matter is filed under Fundamental Human Rights Enforcement Procedure Rules 2009.
I'm not hearing you. And if you move your own, what about the first and second?
Please, let me make my point.
Go ahead, Mr. Mustafa.
Yes, my
Mr.
lord.
Noja, listen.
Yes, and by virtue of Order 8, Rule 4, my lord.
Of the rules of this court?
No, my lord. The Fundamental Rights Enforcement Procedure Rules 2009, under which this matter was filed. Order 8 Rule 4. The court is enjoined to take both the substantive application and any preliminary objection filed by respondents.
Well, you have raised an objection.
Yes, that is the point I'm making, my lord.
Of this suit,
Yes.
stating that the grounds are stated in the notice of preliminary objection.
Yes. My lord, the point is that when such objection is made, the rules make provision for court to take both the substantive suit and preliminary objection raised. If court is minded of taking some, we will appreciate that.
I won't take the two together.
As the court pleases.
Yes.
As the court
pleases. I will take your notice of it. Normally I take two together, but in this case I won't.
As the court pleases.
So I will take your notice of preliminary objection and then. Is there any other party who has to regularize its processes in court?
Yes, the first and second respondent have a motion for extension of time within which to file counter affidavit, and they are not in court.
And we are not taking the main suit.
As court pieces, we can proceed with the preliminary objection, Lord.
So let's, Mr. Mustafa, go ahead.
Yes, thank you, my lord. My lord, the third and fourth respondent filed a notice of preliminary objection.
However, Mustafa,
on the 4th of December.
Mr. Naja, what are you saying? Mr. Mustafa,
what I'm saying is that since the 5th and 6th respondents have taken their own application for extension of time in December, I also have an application for extension of time within which to respond to their preliminary objection. So it will be neater if that is taken first.
Of the 5th and 6th defendants' notice of preliminary objection.
Yes, my lord.
Okay, you have an application to regularize.
An application for extension of time we didn't wish to respond.
Okay.
Okay.
And you
Yes.
have responded. You filed a clean
Yes.
copy.
Yes, my lord.
Very well. When did you file the
So if I
motion?
take that first, we can proceed proper.
Yes. When did you file that
Thank you,
motion?
my lord.
When did you file the application?
It was filed on the 19th of November, 2021, my lord. Okay, then. Yeah. Hmm?
Okay. Mr. Mustafa, any objection to that?
My lord, we are not opposing the application for extension of time.
As
Move in
copy.
terms.
For the other proper. We submit that.
Move in terms of the motion.
My lord, sir. This application, seeking your lordship extension of time, we didn't wish to file process. I will not be objected to, my lord. We'll move in terms of the motion paper. Please, my lord.
Order is as prayed.
As copy.
Go ahead.
Yes, my lord. My lord, the third and fourth dependent respondents have filed notice of preliminary objection. Hello, my lord.
Go ahead.
Yes, the notice of preliminary objection was filed on the 4th December 2020. Urging my lord to strike out this suit for lack of jurisdiction. My lord, we've have 3 grounds upon which we raise the objection. My lord, the first one, as contained in the notice of preliminary objection to save the time of this court.
Very well.
Yes, we also have a written address in support of the notice of preliminary objection, which was filed and dated of 4th December 2020. We seek to adopt same as our argument and submission and urge my lord to grant our prayers. My lord, that's all for the third and fourth.
Well, then for the fifth and sixth.
Yes, my lord, the fifth and sixth respondent also filed notice of preliminary objection.
When?
It was dated it was filed on the 23rd December 2020. 23rd December 2020.
3rd of December.
23rd, 23 December 2020.
December 2020.
Yes, yes, my lord. I understand that it was annexed to a motion on notice for extension of time.
Wasn't even filed as a clean copy.
Yes, I noted that it's attached to the motion.
It's attached to the applicant ought to have filed it.
Yes, my lord.
Like I said in that, I mean, when you attach a process, that
Make it cumbersome.
presupposes that you want the court to know that this is what you intend to do, and seeking the prayer of the court for you to be able to take that action. So
Yes.
the process attached to a motion is just an exhibit.
Yes, my lord, but in the interest of justice and not to delay this matter further, we will be craving the indulgence of my lord to take into cognizance the notice of preliminary objection attached to the motion, and permit us, with your kind permission, my lord, to proceed with the adoption of same. Thank you so much, my lord.
Just a minute, let me have it, because he underlined everything, and I don't know why he did that. Go ahead.
Thank you so much, my lord. Well, my lord, the notice of preliminary objection is challenging the competence of this suit and urging the Honorable Court to dismiss the suit in its entirety. In support of the said notice of preliminary objection, my lord, is a written address which we adopt same as our submission and argument, and urge your lordship to graciously grant our prayers and dismiss this suit. Thank you.
Mr. Onoja. Mr. Onoja.
To the preliminary objection filed by the third and fourth respondent, the applicants have reacted by filing a written address on point of law in opposition to same.
When was it filed?
It's dated the 18th day of November and filed alongside the motion for extension of time of the 19th November 2021. Move this morning. Titled Exhibit A for the third and fourth respondent.
See what we are
applicant.
saying. I wonder what sort of practice when you file a process, you are filing an application, seeking to regularize that application, and you address that process, your motion. You take it upon yourself not to file a clean copy.
My Lord, ordinarily, I'm not. He moved his application for extension of time today.
I'm not talking about your application for extension of time. I'm talking about your reaction.
My Lord,
What's the preliminary objection and the fact that you didn't file a clean copy?
Please come and assist me. If I remove,
I can hear you, Mr. Onoja. I can hear you clearly.
Yeah, increase your volume.
If I remove my phone, doesn't talk out.
Mr. Onoja, I can hear you. Go ahead.
Okay, thank you, my Lord. My Lord, I was saying that he just moved his application for extension of time to file notice of preliminary objection today. So I'm not out of time with regard to his own.
Yeah, but you didn't file clean copy.
I just moved my application this morning.
I said you did not file clean copy of your process, of your...
My Lord, sir, I just moved application for extension of time just now. So I have no opportunity of filing anything. Immediately I move this application that we are proceeding to hearing.
Okay, do you want the court to give you time to go and file a clean copy?
My Lord, the court has deemed it as properly being filed and served. That was my second prayer.
I observe now that it has not been filed, like the fourth and fifth and sixth defendant did. And that's what I'm trying to point out. But next time you don't do that, I will take it today. But next time, if you do that, I won't take it.
As copies,
if you are filing a process and you are asking for a deeming order, you attach that process to the application first and foremost as an exhibit, and then you file a clean copy with a stamp of the court placed on it, with your seal as well placed on it.
Thank you, my Lord. Okay. Thank you, my Lord. But why? Okay. Most grateful, my Lord.
Go ahead.
So Exhibit A is in reaction to the third and fourth respondent objector. And with the kindness of God, I seek your leave to adopt same as my argument in urging your lordship not to decline jurisdiction in this case, as the objection amounts to nothing. In summation, my Lord, sir, we refer your lordship to order 3.
You didn't put that in your written address.
It's there, my Lord, but that's why I said in summation, my Lord.
If you put it there, I don't have the time to listen to that anymore.
We adopt it and urge your lordship to refuse that application, my Lord. In reaction to the fifth and sixth respondent objectors, The applicant has also equally filed a written address on point of law
When was it filed?
alongside the same motion, 19th of November 2021, my lord, sir, titled Exhibit B. With the kindness of court, we seek to adopt same as our argument by urging your lordship to refuse to dismiss the application of the objector, my lord.
Very well.
And finally, my lord, we comment to your lordship a decision reached by your lordship in the case of Honorable Tangod Onumosis and two others versus Kogi State government and two others.
Thank God.
Tangod Onumosis, my lord, and two others versus Kogi State government and two others. In suit number
Is it
NICN.
unreported suit?
Is on a similar issue, my lord, sir.
Listen
It's
to
unreported.
me.
Yes.
We'll file it.
Unreported suit number. Unreported suit number what?
Suit number NICN LKJ LKJ /12/2020. LKJ /12/2020.
Delivered when?
September, March last year, my lord. I'm very sorry, I don't know the specific date, but the ruling is delivered by your lordship in a similar application and objection like this, my lord. That your lordship.
Did you attach the ruling?
I have not obtained the ruling from this court, my lord, sir. It is delivered by your lordship, my lord, sir, in a similar situation.
But if it is delivered by this court, then you should be able to tell me when it was delivered, even if you don't have it before the court.
It was in March, but the specific date,
March when?
Last year.
Well, and then I have to discountenance that.
Yes, thank you, my lord.
My lord, the essence of it is what Order 3 Rule 17 sub 2 says. To convert,
what does it say?
Converting such application to pleading, complaints.
And so you tell the court that, but not that you are telling me. You are citing a decision you said I delivered. You can't remember the date it was delivered. Then how do you want the court to look at it and decide on your case?
I am very sorry, my lord. I am very sorry, my lord. It's within the power of your lordship to look at the process and apply the spirit of Order 3, Rule 17, sub 2 of the rules of this honorable court. Since the subject matter falls within the exclusive jurisdiction of this honorable court.
Order 3, Rule what?
Order 3, Rule 17, sub 2.
Any reply, Mr. Mustafa? On point
Yes,
of law?
yes, my lord. My lord,
Yes,
Did you
sir.
file any reply?
yes,
We
my
did not
lord.
find any reply.
My lord, there was no reply on point of law, but my lord, I want to, respond to the last issue he raised. My lord, this matter is filed under enforcement of fundamental human rights. It's a sui generis, my lord. And my lord, the basis of our preliminary objection, we are arguing that the commencement of this matter, the competency of this suit is challenged. The commencement, my lord, it should be commenced properly, which has not, my lord. And therefore, that order 13, or whatever order of this honorable court, is not applicable here. The only circumstances upon which the rules of court will be applied in enforcement of fundamental rights is when there is lacuna, my lord. The rules that will guide this matter is Enforcement of Fundamental Right Enforcement Procedural Rules 2009. Except there is a lacuna, that is when the rules make provision for applying rules of courts. My lord, this submission made by counsel to the claimant is just affirming the fact that this matter is not supposed to come under enforcement of fundamental rights, which he tried to smuggle it under enforcement of fundamental rights. And when he sees the writing on the wall, he is now urging my lord to convert it to pleading, which is not done under the rules. We urge my lord to discountenance the argument, the submission that this matter be. My lord, if he wish, he can discontinue this matter and file pleading and file a fresh suit. We urge my lord to discountenance the argument and proceed with the judgment based on the preliminary objection raised by the third and fourth, as well as the fifth and sixth respondents. Thank you, my lord.
Let me have the diary. My personal diary there, I asked that they should bring it. Let's adjourn to 1st March for ruling.
As the court pleases. Thank you, my lord. My lord, being from Abuja, is it virtual?
Yes.
Thank you, my lord.
Call the next case. Go ahead, call the next case.
NICM LKJ 07-2020 between Honorable Bello S. Ajiga and 9 others versus 1 Okene Local Government Council, 2 Kogi State Ministry of Local Government and Chieftaincy Affairs. My lord, 7th and 8th claimants are in court. Others absent.
Defendant?
Absent, my lord.
Appearances?
With utmost respect to my lord, I am H.A. Obeito.
Eh?
My lord, I am H.A. Obeito.
For who?
Humbly, my Lord, I appear for the claimants.
Any other appearance?
May you please, Honorable Court. R.O. Mohammed. Appearing for the fourth defendant.
Any other appearance?
Yes, my Lord. Found response to the Honorable Court. Another appearance is for the second defendant. Share with me.
For who? For second defendant.
Yes, my Lord. Yes, my Lord. Appearing with ICD.
I see what?
Duke.
Very well. The matter is for hearing.
No, my Lord, the matter is stated for motion.
For?
Motion, my Lord. Motion.
Which motion?
My Lord, we have a motion for amendment.
When was it filed?
Lord, it was filed on the 15th of November 2021.
16th November.
15th November 2021.
2021.
Yes, my Lord.
Are you in receipt of this application filed by the claimant, Mohammed Esquire and Obaido Esquire?
We are in receipt, my Lord.
Any objection?
No objection, my Lord.
Obaido Esquire.
Yes, we're received of it, but no objection, also, my Lord.
Move in terms.
As a court, my Lord, we humbly demand for the motion paper.
All eyes are sprayed. Have you filed clean copies?
No, my Lord.
Not. So file clean copies within 24 hours.
Yes, sorry, my Lord. We beg for an extension of the date, my Lord. We didn't come from we came from jurisdiction. No, I said, my Lord, we came from outside jurisdiction. We went for 48 hours, my Lord. We wish to do that.
You came from where?
Outside jurisdiction, my Lord. So we humbly beg for 48 hours. We didn't wish to file the clean
Okay,
copies.
file within 48 hours. Serve advance copies on the other parties. You have liberty to file consequential amendment to their defense.
As God pleases.
What date for hearing?
Okay.
What date?
My Lord, 16th of March.
16th March, my Lord. 1-6.
Case adjourned to 16/3/2022 for definite hearing.
As per privilege.
We're grateful,
We're
Lord.
most grateful.
Call the next case.
One, two, state government.
Thank you.
Defendant
Who is in court?
my Lord.
Defendant absent.
Yes, my Lord.
Appearances.
Respectfully, my Lord. B.M. Musa. My Lord, I announce my appearance for the claimant.
Any other appearance?
Yes, please, my Lord. FB of Bayeri.
You are for who? Unmute yourself.
They appear for the defendant, my Lord. Defendant.
Very well. The matter is for definite defense.
My Lord.
So go ahead and invite your witness.
My Lord, we are very sorry this morning.
It's no longer in the morning. This is in the afternoon, 12:51 p.m.
Sorry, my Lord. Our only witness in this case is seriously, my Lord. He has been on admission for months.
And you cannot file an application for change of witness.
My Lord, we intend to do that, my Lord.
After 3 months or 2 months.
I just got the notice just yesterday, my Lord, or just a few days ago, my Lord.
So what do you want the court to do?
We are craving my Lord's indulgence to adjourn the
Mr. Musa, any objection?
No, we reluctantly concede to the application, Lord.
What date?
Eh?
17th March, is it convenient?
Very convenient.
Case adjourned to 17/3/2022 for definite defense.
My Lord, we are very grateful.
Matter.
NICM LKJ 28/2019. Major MJ Adama and Ogi State.
Appearances. No appearance. Neil.
Yes.
Did you serve hearing notices?
Yes, my Lord.
When did you serve hearing notices on the parties?
I should leave.
Case struck out for want of diligent prosecution. Is that all for the day?
Yes, my lord.
Arise.
Oh.